The latest verdict in the Apple-Samsung patent wars was handed down last Friday in the Northern District Court of California. The case involved 4 design patents, 3 utility patents, and trade dress. Apple was claiming that Samsung recklessly copied those intellectual property rights, and the jurors found the same. So the jurors' verdict involves Samsung paying over $1 billion of damages to Apple for the reckless copying, although it should be noted that this damages amount could be multiplied by Judge Koh given the willful infringement situation. The case is one of 50 cases being litigated between Apple and Samsung around the world in over 10 different countries. So just today, Apple has lodged a schedule of Samsung products it wants removed from the market. That is, Samsung products they're looking for a ban on, and they include the Galaxy S 4G, Galaxy S2 ATT, the Galaxy S2, Galaxy S2 T-Mobile, and other Galaxy S and S2 phones. So what's going to happen if this ban is upheld, and what's next in the case? Well, Judge Koh is going to review the damages amount. Samsung is going to appeal the verdict if Judge Koh doesn't override aspects of the jury decision that she feels were wrongly made out. If Samsung appeals, they'll be appealing to the United States Supreme Court, and then if things don't work out there, further to the Court of Appeals of the Federal Circuit of the United States, which is a specialized patent appeals court in Washington, D.C. In a statement Samsung made, they claimed the decision was a loss for consumers. In the short term, yes, it's a loss for consumers, but in the medium to long term, it's a strong win for consumers because ultimately, the reason why Samsung copied these Apple technologies is because consumers like them. And in order for Apple to come up with these new technologies and features, they had to invest an incredible amount of money in research and development. That research and development is incentivized by intellectual property protection. So without the incentivization of protection for new technologies, you don't have the level of R&D investment, and you don't have new features and technologies coming to market as quickly as they would have in a context where patent protection is enforced and respected. Well, I think in this case, Apple CEO Tim Cook has showed very strong leadership in not settling. Both he and the team at Apple obviously had a high degree of confidence in the intellectual property rights they'd filed, that they would be valid, and that they covered Samsung's products, and they stuck to their guns. I think that has led to this very strong outcome. This case will clearly give Apple a high degree of confidence in pursuing its intellectual property rights ever more vigorously around the world. Of particular relevance is another case that is pending in the same court that this jury decision has just arrived from, and that relates to 8 Apple patents, and the commentary is online that those patents, if found valid and infringed, will have a much more significant impact in terms of a damages claim against Samsung. The case has certainly delivered a strong blow to Samsung and a strong message that Apple will vigorously enforce its intellectual property rights, that patent rights around design work such as simplistic product design, such as the iPhone and iPad design, do hold up. That's what design patents are there to protect. So while this has been a blow to Samsung's reputation, no doubt they're re-engineering their products around Apple's patents even as we speak, and have already done that successfully on a number of accounts. So the S3 is clear from this case, and I think we'll see less of these types of conflicts in the future once the current swathe of cases is decided.